Next up is SB 660 by Mr. Leno. So, bill regarding the Public Utilities Commission.
Thank you, Mr. Chair.
Thank you.
Committee members, I'm pleased to follow that last bill with something much less complex. And I present this to you on behalf of the bill's joint author, Senator Benueso. And clearly it has the intent of reforming the California Public Utilities Commission so that it can find its way back to its original mission. And let me first accept the amendment suggested on page 12, item 15. So this will remove the requirement of revision to a proposed decision by publicly a decision be publicly available for at least 5 working days before it's acted upon. There are reasons that we included it. I'm happy to continue that conversation with the committee as to why we think it's important, but it is taken as an author's amendment to remove it for now. And I thought it might be of some value just to state the CPUC's own mission statement as we begin this conversation. They describe their mission as, quote, serving the public interest by protecting consumers and ensuring the provision of safe, reliable utility service and infrastructure at reasonable rates. So keep that in mind as we review all that's happened in recent years. Of course, the tragic San Bruno explosion, which killed 8 people when an entire neighborhood went up in flames because a gas pipeline severed, broke, exploded, that PG&E wasn't even aware was there, or was it seemed, wasn't it seemed, didn't have the records to back it up. CPUC, which is supposed to be regulating this utility, didn't have a clue either. We've seen through 65,000 emails the kinds of secret conversations that were ongoing as decisions were made with regard to the San Onofre nuclear plant closing and revealed serious flaws in the management structure and operation of the CPUC. And we believe that these emails strongly demonstrate the relationship between the Commission and its regulated utilities as being far too close and too informal to inspire the kind of confidence that ratepayers and non-utility interests must have for the Commission to be able to do its job. So SB 660 is intended to address the flaws in the CPUC process and operation, and it has 3 major components, and I'll go over them as succinctly as I possibly can out of respect for the committee's time. First, it will revisit and limit the powers of the Commission President. Currently, President, and this is irrespective of any personalities, the way it operates now is that the President really can rule the Commission as his or her own without any consultation with any other of the 4 commissioners, directs staff, directs everything on the President's own. So this bill would democratize the Commission by eliminating the power of the President to directly manage the Commission staff or agency heads. So instead, a full Commission would be authorized to direct staff and to delegate functions to committees and to assign new proceedings to 1 or more commissioners. So that's part 1. Part 2 would create new standards for determining whether a commissioner should be recused for bias or prejudice. Amazingly, despite substantial evidence of bias and prejudice in the past, the CPUC has never once determined that a commissioner should be disqualified based on its current legal standard that requires a determination that a commissioner has, quote, an unalterably closed mind. So that threshold has never been met. This bill changes that unalterably closed mind standard to the appearance of bias or prejudice. And then the third part, which is probably the more substantive part of the bill, sets new rules for ex parte communications between CPUC decision makers and the companies they regulate, that they're supposed to be regulating, and sets clear penalties for those who break the rules. So we both expand the list of CPUC decision makers to which ex parte rules apply, and then also limits the circumstances under which these communications are allowed. So, just to review what current law presently authorizes, and that would be communications without all parties present are prohibited in adjudication cases. They are permitted with some disclosure in rate-setting cases and are allowed without any limits or disclosures in quasi-legislative cases. So that's the status quo. This bill would expand the existing prohibition on ex parte communications in adjudication proceedings to include rate-setting cases, while allowing ex parte communications in quasi-legislative cases if it is disclosed within 3 working days. The goal is not to isolate CPUC decision makers. It is to ensure that in rate-setting proceedings, such as the San Onofre nuclear power plant closure involving hundreds of millions of dollars of ratepayer money, decisions are not made in secret. It's important to note that while the bill prohibits ex parte communications in rate-setting proceedings, oral communications involving all parties in that proceeding or written communications provided to all parties on the same day are expressly allowed. That's not isolation, it's just basic fairness. We would also continue to allow ex parte communication in quasi-legislative proceedings so long as it is disclosed within 3 working days.
Second.
So I know you have a hearing with regard to the Strumwasser report coming up this afternoon. I'll spare you a few more details, but many of the suggestions coming from that report we have included in the bill. And then just to conclude that how this will all work, one thing that we've seen over the past years is that there have been lax ethical standards by regulated entities, commissioners, and CPUC employees, and the bill provides for civil sanctions decided by the Commission for the violation of the ex parte rules by any entity or person except a decision maker or employee of the CPUC. For Commission decision makers and other employees, this bill gives the Attorney General the authority to bring an enforcement action decided by the Superior Court to assess civil sanctions against any decision maker or employee of the CPUC who violates ex parte rules. So, bottom line here is no more secret off-the-record meetings that determine the fate of utility policy in the state that will impact ratepayers and every pocketbook of our constituencies. I'm happy to take any questions and would ask for your support in what I think is long overdue revision of how the Commission operates and our job in making sure they stay true to that mission I shared with you at the beginning of my presentation.
Thank you, Senator. Others in support?
Thank you, Mr. Chairman, members of the committee, Senator Leno, Matt Friedman on behalf of TURN. Committee members, now is the time for PUC reform, and this is the bill to make it happen. We've all read the press. Everyone knows this is a very hot topic, and that the legislature needs to lead. The PUC is not going to reform itself. There needs to be external pressure applied, and this legislature is the place for that pressure to originate. We have worked very closely with Senator Leno on the development of SB 660 and his staff, with Senator Hueso and his staff, and we appreciate all of the support and input from you, Mr. Rendon, and your staff on this bill. As Senator Leno indicated, the bill has 3 basic components. I won't go into detail, except to say the following. The democratizing of the PUC management and oversight. This is really intended to address the problem when you have too much power in the hands of a single individual running an agency. And the past abuses at the Commission can be directly traced to the consolidation of the power in the President. it created a bad culture that encouraged the exact kind of abuses that are now hitting the papers. And the key way to reform that process is to involve all 5 commissioners in the management of their own agency. Make sure that they have to work together to manage key staff and that they can bring a higher level of accountability and competence to the management of that agency. With respect to the second element, as Senator Leno indicated, we have been wholly unsuccessful in ever disqualifying a commissioner for being too biased or too deep in the weeds or having been too actively engaged in trying to push utilities to take particular actions. We have tried repeatedly and we have failed, and we have concluded that the only way to get a better standard in place and a better process in place is through legislation. On ex parte reform, the goal is to take conversations out of back rooms and to make them public conversations so that everyone knows who is talking and what is being said. The provisions of SB 660 would cover a greater universe of individuals, both in terms of those on the outside of the agency and those within the agency. It would eliminate private ex parte meetings in rate-setting cases, which are the bulk of the Commission's cases. That's really the meat and potatoes of the work that the PUC does. It would require reporting in the quasi-legislative or policy-oriented proceedings, and it would establish meaningful penalties for violations of the rules. When the potential upside is hundreds of millions or billions of dollars for a utility, the threat of a $50,000 or even $1 million penalty is inconsequential. That's a cost of doing business, and the rules need to be changed to create more effective deterrence, especially when so much money is on the line. The bill also ensures that there is a process in the event of impermissible ex parte communications, and that there is enhanced reporting by the PUC commissioners and staff themselves. These changes would bring the Commission in line with the practices of other California agencies, other public utilities commissions around the country, and other federal agencies that perform similar work. I know Mr. Strumwasser is going to be presenting on his report later, and he goes into great detail in making the case that the Commission is out of line with typical practice around the country. If SB 660 does not prevent any individual or party from communicating their views to the Commission, it simply requires that those communications be publicly disclosed and communicated outside of the back room. Again, the PUC is not going to reform itself. We think that this bill offers an excellent path forward. It gives the Commission plenty of work to do to implement the various provisions. It represents meaningful reform, and hopefully it is a key step in changing the culture of the Commission. Thank you.
Thank you.
Mr. Chair and members, Ignacio Hernandez on behalf of the Consumer Federation of California. We are also in support of the bill.
Others in support of this bill?
Elizabeth Byrne on behalf of Sierra Club California in support.
Thank you. Thank you.
Strella Service on behalf of the California Environmental Justice Alliance in support.
Thank you. Others in support? Is there anyone who wishes to speak in opposition to this bill?
Mr. Chairman, members of the committee, Senator Leno, Michael Day, I'm representing 6 individuals with extensive PUC practices were not representing. Very, very importantly that we need to talk to you about unintended consequences of this bill. I do want to say that we've noted the recent amendments, and several of them, including ideas that we offered to the Little Hoover Commission and in the Senate, have been accepted, and we appreciate that. The notion of more substantive reporting of ex parte contacts is an essential idea. The idea of stricter enforcement penalties we also strongly support. And the idea of requiring the PUC to use a summary log to say what contacts have happened so you can then check and make sure that the reports have all been filed that should have been filed. Also an excellent idea. And we do support the idea of serving revisions of PUC decisions on all parties electronically. We didn't like the 5-day rule thing, so I gather there will be further discussions about that, but we still think that is an important transparency provision as well. But the main thing we have concerns about is the effect of the ban on individual ex-parte communications in rate-setting cases. That is an incredibly important safety valve for parties who don't have the resources or the ability to participate in PUC proceedings. Even the parties that we typically represent, cities, counties, environmental groups, consumer groups, developers of renewable resources, these parties have to spend a lot of their own money to participate in PUC proceedings. And yet, frankly, we often end up being the tail on the dog, where the major issues in a rate-making case are between the staff and TURN and the utilities, all of whom have substantially more resources to deal with some of these things. And so it comes to the end of the case, and everybody's dealing with those issues, and our issues are not getting dealt with. And they're not being adequately explained. In some cases, they're not even adequately understood by the ALJs. And the ability to go in and talk to the commissioners and their advisors and explain what's going on in a case that took months and months to try is crucial to having the voices heard of all these segments of the California economy that are not represented by TURN, which is just the residential ratepayer class, not represented by the commission staff, which also looks just to the residential ratepayer class primarily. And, of course, the utilities themselves, who have a tremendous advantage in the hearing room because their lawyers, their expert witnesses, are also paid for by ratepayers, and they also have control of the most important thing of all, their information. What did they do? How much money did they spend on something? They have that information, and we spend our time trying to get it out of them, and it's unbelievably difficult. So for those types of parties, the ability to explain your position to the commission is essential. And saying you can't have this except in a meeting with all other parties present is unworkable. I participated in hundreds of all-party meetings in my career. Everybody except the utility and the staff get very small amounts of time, 3 to 5 minutes, to explain what happened in a 4-month-long case. That's useless, essentially. And then there's a whole other group of stakeholders you need to be very concerned about. The parties who cannot afford to participate in PUC meetings. They can't afford the attorneys and the expert witnesses to show up in the hearings. Community groups, ethnic groups, smaller groups that just occasionally show up when an interest affects them. And so many more PUC proceedings are dealing with so many more issues affecting so many more people. There are a lot of people out there who have to communicate directly to the commission. And this, we are afraid, would actually have the effect of eliminating that avenue for all these different segments of the community and the California economy. And who would benefit is that the utilities themselves, the larger utilities, would have more control over PUC decisions because the hearing room is where everything would take place. So we strongly urge amendment of the bill to retain individual ex-parte meetings, properly reported with strict enforcement. All of the things that we agree with the senator should be done. Thank you.
Thank you. Others opposed?
My name is Faith Bautista. I'm the CEO of National Asian American Coalition. We're the members of the National Diversity Coalition, which includes 5,000 AMA churches, 40,000 Latino evangelical churches, and the Los Angeles Chamber of Commerce. We appear more frequently before the CPUC than any other minority grassroots organizations. This includes the current Sempra GRC, all the key electric vehicles, and the upcoming PG&E 27 general rate case. Our members, including the leadership of the nation's 40,000 Latino evangelical churches and our nation's 5,000 AME churches, include the senior pastors of Christ Redeemer. First, we commend the governor for his appointment of Michael Picker, a leader the minority community has confidence in. We believe he can effectively represent the commission and the governor's desire for a fully reformed CPUC that is dominated by utilities or other special interests. Second, we have great confidence in the governor's appointee and special advisor to the commission, Ed O'Neill. We have read and generally concur with his report on CPUC modernization and reform. Third, in general, we support the ex-parte recommendations presented by Mr. O'Neill. We have had main experience of with the CPUC. I've been involved since I was with Greenlining in 2004, and our General Counsel, Robert Ginesta, and has been involved since 1971. We would like to make a few modest observations on behalf of community groups. One, the entire CPUC process is artificially dominated by lawyers, and with few exceptions, they are lawyers who work for utilities and are highly paid. Second, the public and its participation is an afterthought. In fact, in most cases, there is no public input. For example, the testimony.
Ma'am, excuse me. Are you speaking to SB 660 by Mr.
Yes.
Leno? This
Yes.
is not for the informational. Your statement is
Yeah,
not
for the SB 66. I'm just trying to inform everything also what's happening in the community groups and the CPUC.
relative to 660. Okay.
Yes.
Thank you.
So in fact, in most cases, there is no public input. For example, the testimony at public participation hearings is not part of record and is ignored. Most of the time, commissioners are not even present. Two, Mr. O'Neill report to you demonstrates that proceedings are unduly complicated and burdensome. The result is that the public, even with the facing 2 billion rate increases, does not understand why there is a need of rate increases or the consequences. Mr. O'Neill is correct when he states that CPUC does not currently have an effective governance structure or process for executive level management. This makes it difficult for impossible to the commissioners, no matter how hardworking and knowledgeable, to grasp the big picture. This is particularly so when the big picture is presented by the community groups that don't have and cannot afford lobbyists or price lawyers. The bottom line is ex parte is going to be very hard for nonprofits, organizations like us that only probably have one lawyer. A lot of the even community groups, churches do not even participate. So if you're going to allow more ex parte, it's going to be more complicated.
Thank you. Others in opposition? No one else in opposition? Okay, let's go to questions or comments from committee members. Mr. Obernolte?
Thank you, Mr. Chair. Mr. Leno, I want to commend you for bringing the bill forward. It's clear that you spent a lot of time and energy in this. I had a question about the language on the disqualification of commissioners from decisions.
Yes.
So I understand that in the proposal to alter the standard from unalterably closed mind to appearance of bias or prejudice, the object is to create a stronger standard. But I have a concern that that also opens up the discussion to disagreement over what constitutes the appearance of bias. So even though we're going from a weaker to a stronger standard, you're going from an objective standard to a subjective standard. And could you address that concern?
So I appreciate the comment. I think there's going to be some subjectivity no matter what the standard is. Even something as definitive, or apparently as definitive as an unalterably closed mind, has subjectivity to it. So the appearance of bias or prejudice, a case would, of course, have to be made, and I'll have my legal counsel address some of the more particulars in a moment. But clearly, a case would have to be made, and I think we're familiar with bias, prejudice, any sort of conflict of interest. So I think it's quite workable. Matt, you've got something to add, I'm sure.
Yeah, the provision that you're referring to really has two key components. One requires a new process. Right now, if a commissioner is accused of bias, they get to rule on the motion themselves. And that's really not acceptable. So it requires that a neutral third party, basically within the commission, handle such motions for disqualification. But with respect to the appearance of bias, the bill does actually put some meat on the bones there. It provides some very specific criteria that the commission should apply. It has to do with actions taken by the commissioner during the course of the proceeding, private communications before the commencement of the proceeding to influence the request for relief that would be sought by the party. In other words, the commissioner says, hey, why don't you come in and propose X, Y, and Z, and then they come in and propose it. Maybe that commissioner shouldn't be voting on something if they effectively ask the party to bring it before them. And the third is actions demonstrating any commitment to provide relief to a party. So there's an attempt to actually constrain this a bit, not just to say, do you seem biased or not? It actually is looking at concrete actions that have been taken by the commissioner. And I think we anticipate that the commission would take these statutory criteria and establish more specific rules around it as part of an implementation process so there'd be greater clarity. The appearance of bias standard is an accepted legal standard for disqualification. And in fact, it is the standard currently that applies in adjudicatory proceedings, which are like enforcement proceedings of the commission. But that standard does not apply in rate-setting proceedings, which, again, are the meat and potatoes of the commission's work. where the Commission has held this unalterably closed mind standard applies, which is effectively impossible to satisfy. So what we're trying to do is borrow from an existing standard that is already applied in adjudicatory proceedings, and then add some additional criteria that we think actually narrow it and don't allow it to be overly expansive. For example, there's also a provision in the bill that says the past work experience of the commissioner or the judge can't be used to demonstrate bias. I mean, everyone worked somewhere before they came to the commission, and so it wouldn't really be fair to say you can't vote on anything because you worked at a company that was involved in the energy industry, right? You'd never get anybody to serve at the commission who had relevant experience. And so we're trying to do these things to kind of constrain the types of concerns that can be raised in this process. Is that helpful to you?
Oh, it is. I'm familiar with the fact that the appearance of bias or prejudice is an existing legal standard, but I've also been part of proceedings in the past where someone challenged what exactly that meant, and that led to a long discussion about whether or not the appearance of bias was present. And I just wanted to make sure that we were thinking about the fact that that could occur, but it sounds like we are, so thank you very much.
Thank you.
Thank you, Mr. Obernolte. Mr. Hadley?
Thank you, Mr. Chairman. Senator, thank you for bringing this bill forward. I agree with you 100% that the time to reform the PUC is upon us, and I am encouraged by this bill. I do take seriously the statements made by the opponents, and I would ask you to directly address them, if you will.
Thank you, Assemblyman Hadley. There was the suggestion that this bill will have the unintentional consequence of harming smaller stakeholders that might be disadvantaged. And among those were included cities and counties, but you don't see the League of Cities here today, and you don't see the California State Association of Counties here today. Consumer groups, they're not in opposition, they're in support. California Environmental Justice Alliance, also an environmental group. Of course, the California Federation of California was already here to express their support. The Greenlining Institute also is in support. So community groups, ethnic groups, they're just not here. I understand. I know this gentleman has more experience before the CPUC than I do. I'm sorry, sir, I don't know your name.
Mr. Day.
Mr. Day, thank you. But I don't know that Mr. Day is the voice for all the groups that he is concerned about, and are clearly not here to express their own concern. And I would doubt that anyone would argue they don't have a voice of their own that they could use to express their concern if they had one.
Assemblymember, we have a difference of opinion with the opponents on this particular provision. We see close up on the front lines how ex partes work. Mr. Day certainly is awfully familiar with it himself. The reality is that the utilities have extensive staffs of regulatory relations folks who do nothing but spend their time trying to get meetings with commissioners and their staffs. This is how the process works today. And the deck is stacked against small interests, the way the commission is organized. Even groups like TURN, which Mr. Day says has extensive resources, we do not have even a small percentage of the resources of the large utilities. And we have little time to go walk around on the 5th floor of the PUC headquarters and go meet with all of the advisors on all the cases and try to get meetings with all the commissioners. We do it as needed, but we would prefer not to. We'd prefer to let the evidence in the case speak for itself. And for the parties that don't have the resources to participate in the hearings and to have expert witnesses come in, there are many avenues for communicating concerns, even under the rules that would be established by SB 660. Specifically, parties, any individual, any community organization or civic group can send letters to the commissioners. Letters can be submitted on any issue that is in a rate-setting case under 660, so long as other parties get access to it. You serve it on the list. This is what a lot of other state agencies do. When individuals or groups submit letters, they post it on their website so everybody can see. The Commission also has public participation hearings around the state where individuals can go and express their concerns at length about pending issues that are out in front of the Commission. Oral arguments, all-party meetings. There are a lot of ways that small groups can communicate even under the restrictions of 660. What they can't do is communicate in private where nobody really knows what was said. That's the avenue that we are attempting to cut off. And it is my firm belief that the utilities take far greater advantage of these opportunities than all of the small community, civic, religious groups put together times 10.
Thank you very much. That's helpful.
Thank you, Mr. Hadley. Other questions? Great. Would you like to close? Oh,
Yes.
we have
Please, yes.
a comment from a tweener, I believe.
Yes, thank you, Mr. Chairman. Carolyn McIntyre, representing the California Cable and Telecommunications Association. We also commend the senator for bringing this bill forward and to propose the reforms that are before us. We are concerned, however, that there are a couple of them that continue to need some clarification. Our fear is that they will have the unintended consequence of creating a situation where we need to have communications with a division director, for example, because they are a party to the proceeding, and this bill is not clear that we would be able to continue to do that. I also think there's some clarification needed in a few areas that to state that we truly are talking about proceedings that are open before and pending before the commission, as opposed to any types of communications that may be taking place. Lastly, we had some discussion earlier with regards to what is a prohibited ex parte communication in the broader sense of requiring someone to file a notice that they actually violated the law. So what we'd like to see is an opportunity to continue to work with you on these issues. I believe that they're possible. It's possible for us to resolve them.
Thank you. Ms. McIntyre is, of course, representing the California Cable and Telecommunications Association, which sent a late letter. I wouldn't call it a letter of opposition, a letter of concern. Yes. That was sent over the past few hours. I know a number of committee members had questions about it, so we wanted to give her the opportunity to discuss it. Senator Leno has...
So as did the commission receive this just yesterday? So have we, and so we're looking at it, and I'm sure we'll have further conversations with the CCTA and with Ms. McIntyre, and happy to see where we can reach some agreements.
Great. I will note that we did previously submit a letter, and there have been some efforts made to resolve the issues. We're just not quite there yet.
So noted.
So it sounds as though Senator Leno is committed to...
I don't know that we're going to find agreement
Right.
on all, but I think at least on a couple,
Certainly
yes.
Committed to talking and moving the dialogue forward.
Without a doubt.
Thank you. Would you like to close?
You have been more than generous with your time and interest and consideration, so I ask for your aye vote.
Thank you, Senator. This is part of an ongoing effort on the part of yourself, Senator Wessos, Senator Hill, myself. I have a bill that I hope to present in the next half hour downstairs on ex parte logs as well. There's issues relating to transparency, accountability. I had an effort aimed at judicial review within the PUC that unfortunately was taken out during the appropriations process, but I think something that needs to be looked at as well. Again, thank you for your efforts and thank you for your work on this bill. We have a motion from Mr. Hernandez and a second from Ms. Eggman.
And the motion is do pass as amended to appropriations. Rendon?
Aye.
Rendon, aye. Patterson?
Aye.
Patterson, aye. Ashajian? Bonilla? Aye. Bonilla, aye. Burke? Aye. Burke, aye. Daly? Eggman? Aye. Eggman, aye. Garcia? Hadley?
Aye.
Hadley, aye. Hernandez?
Aye.
Hernandez, aye. Obernolte?
Aye.
Obernolte, aye. Quirk?
Aye.
Quirk, aye. Santiago? Aye. Santiago, aye. Ting, Williams.
I'm coming back to this committee. Thank you.
That bill is out.